Good morning. All right, this is a code enforcement hearing for the City of North Miami. Today is April 3rd, 2019. I'm Christopher Benjamin, Special Magistrate for the City of North Miami. The purpose of this hearing is to determine if a code violation exists at your property or existed by a code enforcement officer of this city, as cited by a code enforcement officer of this city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, therefore, all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording devices. If English is not your primary language, then please inform me when your case is called, and we have interpreters who will assist you during your proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should come forward to the podium on the left side of the room. When asked, please speak directly into the microphone and say aloud your name, your business address, or your mailing address in your relationship to the property. If you're not the property owner or an attorney representing the property owner, then you will need a power of attorney in order to speak on behalf of the property owner. For new cases, you're going to be asked if for the record, if you are aware of and understand the nature of the violations that are being heard today and whether you understand what is required to resolve those violations. So please answer accordingly. The city will present its case first, and then the property owner will be given an opportunity to testify on their own behalf, to bring forward witnesses to testify, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I'm going to issue a finding of fact on the case, and if I find that a violation of the city code exists or existed at your property, then depending on the case type, I'll set an abatement date for the violation to be resolved, or for repeat violations, I'll impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a later time should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement at this time, then I'll table the case proceeding for another hearing in the near future. If you do not agree with my findings of fact, then the property owner may appeal the administrative order on the case to the circuit court, this being Miami-Dade County, that's the 11th Judicial Circuit. An appeal must be filed within 30 days of the date of the execution of the administrative order that is to be appealed. Now, in accordance with Florida statutes, if a person decides to appeal my decision made today with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost for obtaining the verbatim record shall be the sole responsibility of the appellant, meaning the person appealing. And it is recommended that the persons who plan to appeal their case should provide their own court reporter at these proceedings for all expedience. Pursuant to the city code, if the city of North Miami prevails in prosecuting a case before this special magistrate, then the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien, the city will then charge an additional administrative fee in order to record the release of that lien. Now, if you're going to be giving testimony today, please rise and raise your right hands for the oath and remain standing for the Pledge of Allegiance.
If you're going to be speaking on a case up here, please raise your right hand. Raise your right hand. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do. I do. Please all stand for the Pledge of Allegiance. Let's face the flag, repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Translators. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skills, and ability? If so,
Say I do.
aloud, I do.
I do.
Thank you, please.
Madam Clerk, Announce your additions, deletions, or corrections to the agenda, and then call your first case.
Item number 8, CEZPU 2018-00067 was complied. Item 13, CEEXP 2019-00031 is complied. Item 14, CEFAW 2019-00045 was postponed to May. Item 16, CERCV 2018-00270 was postponed to May. Item 27, CERCV 2018-00267 is complied. Item 29, CEDSP 2019-00001 is complied. Item 30, CEGEF 2019-00001 is complied. Item 32, CEMIS 2018-00011 is complied. Item 33, CEMIS 2018-00013 is complied. Item 34, CEMIS 2018-00014 is complied. Item 39, CEJNK 2019-00006 is complied. Item 44, CEGMP 2018-00392 is complied. Item 50, CEEXP 2019-00024 is complied. Item 51, CEGMP 2019-00013 is complied. Item 55, CESOD 2019-00012 is complied. Item 56, CERCV 2019-00018 is complied. Item 59, CEIVY 2018-00406 is complied. Item 61, CEGMP 2019-00012 is complied. Item 69, CEIVY 2019-00022 is complied. Item 71, CEPFY 2019-00047 is complied. Item 74, CEIVY 2019-00003 is complied. Item 75, CEEXP 2018-00263 is postponed to May. Item 80, CEREL 2019-00003 is complied. Item 83, CEODS 2019-00008 is complied. Item 85, CEZPU 2019-00013 is complied. Item 89, CEOSV 2019-00008 is complied. Item 90, CESSP 2018-00302 is complied. Item 93, CEPFY 2019-00046 is complied. Item 108, CEGMP 2019-00017 is complied. Item 111, CEOSV 2019-00009 is complied. Item 115, MHVIO 2018-00260 is complied. Item 116, MHVIO 2018-00349 is complied. Item 117, CEFAW 2018-00346 is complied. Item 123, CEWWC 2019-00010 is complied. Item 126, CEGMP 2019-00027 is complied. Item 127, CEGMP 2019-00028 is complied. Item 128, CEPFY 2018-00638 is complied. And those are all the deletions and amendments to the agenda. The first item is item 35, D&D Company Properties. John Dorville is the officer. The case number is CEZPU 2019-00015, item 35.
Who's here on behalf of this matter?
Good morning, Your Honor. Ben Fernandez, 200 South Biscayne Boulevard, on behalf of the property owner, D&D.
Okay. And what's your relationship to the property?
I am the attorney that representing the property owner.
Okay. Counsel, your client's been made aware of the violation. Are there any objections?
Our only objection is that we feel that there is no violation, and we'd like to state
Okay.
our reasons why.
All right. Mr. Dorville,
Good morning. Good morning.
Make your appearance and begin your case.
Absolutely. John Dorville, City North Miami Code Compliance Office. This case obviously is in reference to a zoning issue at, I cited them for CEZPU 2019-0015. The property was initially cited, let me give you this information here. For that case, actually had, another officer had some cases open in reference to this particular property. But my case was, I felt as if my case was the one that encompassed all the issues. The issues is that this property, and I have pictures, is operating outside its mandated, its applied zoning. I have pictures, and I'll show it to the attorney. They have trailers on property that are consistently on property, never moved. They currently, as of yesterday, they had a dumpster on the property. There's pictures I have also from the orderly fashion in which the trailers have blocked off an access road. They're sorting and storing items outside the property as well. This actually is not a new issue. I have some pictures here from a previous officer that go back as far as 2018.
Thank you.
I've had conversations with the property owner. I actually returned a phone call to the attorney's office, but was not called back. Obviously the issues are, it's pretty straightforward. They're operating outside their zoning. They're blocking an access road. The obvious thing here is that this particular business has outgrown its actual space, and the pictures will demonstrate that. I also have as well an email from zoning that is in my email system and can be provided to the court, and referencing what their zoning is. I did speak to the property owner. I extended him the information, the individual contact to speak to at zoning, in reference to have a conversation and to be educated as to what their specific zoning is and how they can operate in that manner. But as you can see through the pictures, this particular property is operating quite clearly outside of its zoning.
I'll give council an opportunity to look at the photos while
Uh,
you go
Thank
forward.
you. Thank you, Your Honor. Thank you, Inspector Dorville. And thank you for reaching out to me. I was recently retained on this, so I haven't had the opportunity to fully discuss this with Inspector Dorville. He did call me back. I did reach out to him. He did speak with my client. The ownership is not local, and so there's a little bit of a delay there. This morning, I reached out to you only a little while ago and said, is there any possible way to achieve compliance in his view with this matter? And he said that we could possibly talk about it after the hearing, but that now would be inappropriate. Our position, Your Honor, is basically that this is a thrift store that's been in operation for many years in the city of North Miami, and it employs over 150 people, is my understanding. I have the manager here, Ms. Ida Rosario, who will speak, as well as Mr. Eddie Cruz, who is the manager of the truck loading operation. They have both been employed, Eddie Cruz since 1983, and Ms. Ida Rosario since 1994. I was just there before I came in. It is a thriving operation, important, I think, to the community, not just in terms of employment, but also in terms of the service that it provides, the retail clothes and thrift items that it provides. I think they do
So
a
why
very...
does council believe that it is not operating outside of its zoning?
Well, I will say that in looking at Chapter 29, Article 4, the definitions of a retail establishment, my understanding, I think, is that this is zoned for retail use. It's, I believe, C3 under your code. And retail operations have a prohibition and require that everything take place within an enclosed building. However, in the definition of a thrift store, which I will introduce for the record and share with the inspector, reads that a thrift store or resale shop means an establishment wherein secondhand articles are sold, such as clothing, shoes, accessory furniture, and other assorted items, the value of which is only a fraction of the original cost, for which price guides are not available and which normally have no collectible or antique value, etc. Meaning that that prohibition or the requirement that everything take place within an enclosed building is not in that definition. Now, I haven't had an opportunity to explore the permit records for this site, but I do have aerial photographs that I will introduce for the record as well that show that the loading and unloading of merchandise, which is what's taking place here. There's a high volume of loading and unloading because of the amount of business that they're doing. And so I have Google Earth images dating back to 1994 that show this very same operation taking place on the property. So let me provide that. Here are the definitions, and here are the images. The other point I think that was raised is that this is blocking some sort of an access.
Counsel. You can make you can make arguments. You can speak on the record. You can speak on the record. You can make arguments.
Okay.
No, it's your case actually. You represent the city. You can do it from your seat. You can do it from your seat.
So,
Just make your appearance and then.
Shayla Vasquez on behalf of the City Attorney's Office.
You have any?
Yes, Judge. We do have an objection to the photos. I don't know how photographs from 1994 are relevant to the case. 2019.
I
In
think
addition,
I think council's just seeking to establish some background information showing that the activity of this particular activity that's in question today has existed for some time at the property. Am I correct, counsel?
that is absolutely correct, Your Honor.
And in terms of, I did not see where these definitions came from. It's just kind of typed up.
Yeah.
I would state that those are also not relevant. We don't know where they come from. We don't know who's defining these definitions. We don't know if it's a summary from counsel himself. But in terms of what counsel stated, when it comes to the loading and unloading of the merchandise, he stated it was an ongoing operation. They can't have all of those, and I'm referring to the photographs that were introduced into evidence. They can't have continuous dumpsters and a continuous operation where those do not leave the property. And correct me if I'm wrong, Mr. Dorville, those are always there.
The dumpster is actually new. It's been on the property for about roughly a week or so, but the trailers have been consistently on property since I've been in the zone. And prior, I could probably bring up testimony from other code officers from the area.
So the issue is storing the dumpster. They're storing
The trailers on the property, because those trailers, one, are outside their zoning. Two, are actually blocking the access road as well.
Well,
And it's a safety issue.
Counsel, address the issue as to where you obtained the definitions.
the definitions are from Chapter 29, Article 4 of your code, the definitions section in the land use regulations. I can pull them up. I apologize for not having the actual number, but I can pull it up right now on my phone and share it with your city attorney.
I can pull it up as well.
Okay. And also, I'd like to say, with respect to the public access, I'd like to submit for the record a copy of the Biscayne Park Estates subdivision plat, which is a matter of public record as well. And it shows that there is no alley that runs through this property, that there is a walkway that takes a turn to the west and surrounds the area in question, but there is no alley that bisects the area where the loading is taking place and where the store is located. Show you, this is the plat, this is the area, and then this is a blow-up of the plat, and you can see that the walkway goes around the property.
Okay.
This is a little confusing, I apologize for not being perfect. This is the Biscayne Park Estates plat.
You don't take the pictures?
Can't page you the ORP page.
He's
This
on
is
his way?
the
I'll just
blow-up
ask
of
him.
the area.
Okay.
And this is the walkway, so the loading is taking place on lots 59 and 60 here, and the store is located here, and the walkway goes around it. So this is all our client's property.
And where's this from?
This is the recorded plat of the property from the Miami-Dade County Clerk's Office.
Yeah. Magistrate, I have Derek Cook from zoning. If we can table this for a few minutes, I have Derek Cook on his way to discuss. He's the zoning manager to discuss the issue outside of,
Wait,
to give us more specifics on
well, you're
the
saying
zoning.
they're outside of their zoning purpose because of the storage of trailers upon the property.
Correct.
So, why don't we address that issue, counsel?
Yes. And also, for the record, I'd introduce our log of the trucks that visit the property since 2016 through the present. And it shows that these containers are moved on a daily basis. I mean, we will concede that they are there during the day, but they are moved. It is a new container each time, bringing new goods to the property. The issue is that the container needs to be unloaded, and they're, you know, individual household goods and clothing items and so forth. It takes time to unload it, get the stuff into the store, and then move it out and get another one in. So what's happening there is that you see loading taking place on a daily basis, but it is a different container that is coming in every time.
City of North Miami Co-Compliance Manager Crystal Cordell, Special Magistrate. This case dates back to, I want to say,
Crystal,
summer.
so you need to be
Summer,
you need to be sworn in.
Oh, I'm sorry. No, I didn't.
Do you swear or affirm that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say I do.
I do. This case dates back to, I want to say, maybe summer of last year. Another zone officer, Wayne Clark, was initially dealing with it. It was initiated by one of our council persons that contacted me, referenced not being able to drive through the rear of that area and just all the congestion.
Not being able to drive.
Just behind, there's a Walgreens that abuts the business, and there is some right of way and some driving, just some, driving areas back there that just not accessible due to the congestion. So
You're saying that the business is so successful that it causes traffic.
basically. So we went out. I personally went out to the property. I was floored at the situation.
Y'all like that thrift store, huh?
Our residents like the thrift store. So from the right-of-way, 6th Avenue, it's not visible necessarily. When you if you're not shopping there, you wouldn't notice it. You go back there, it's insane. So I went back there. I personally spoke with the store manager at that time, who put me in contact with who I believe might be the CEO of the company, who's out of California. I had a conversation with him at that point, and he explained to me that the business had been in existence for several years, 40, 50, 30, something like that. He conceded that they have outgrown the space. Essentially, what's going on is that they have outgrown the facility.
Here's the problem for these proceedings. Whether they've outgrown the space or not is not a matter for me to decide.
Mm-hmm.
The issue for me to decide is whether, as Mr. Dorville has said, they are operating in such a way that they are beyond the scope of their zoning, like their zoning permissions. In this particular instance, Mr. Dorville has has directed my attention to the fact that there are trailers on the property that are being stored continuously, and that as such, that storage of these particular trailers is the linchpin of this particular violation. Am I correct in that summation, Mr. Dorville?
Yes, sir.
Okay. Counsel, in argument in contesting this, says that these trailers are storage containers that are moved on a daily basis and thus are not there continuously on the property. That perhaps when Mr. Dorville comes, there's a container on there, but because they have daily activity that involves containers, that is the case. But at some point, I'm assuming that the trailers are moved off the property, I guess, after closing or something. I haven't.
So-
But he provided a log. He provided a log for you. So, I mean,
That is correct, and I will just say that my client is willing to work with the city if the issue is the unsightliness or, the way that the operation is taking place. We're happy to have this conversation with Mr. Cook to come up with, some sort of a
Magistrate, I believe, I'm sorry to interrupt, but I believe we're talking about the crux of the situation is the trailers being on the property. If I move a trailer and replace it with another trailer, isn't that considered continuous?
well,
If I have a car in a parking space, right, and I replace it with another car, is that space still taken up? So essentially, at the end of the day, if you replace one trailer and put another one, I mean, for whatever time period that is, it's still operating outside your zoning because you have continuous storage on the property. Replacing one without another does not negate the fact that that's continuous.
I would disagree with that.
I will pass on the log. by the
I would disagree with that because if you have a parking space and you replace it with another parked car, that doesn't mean you're storing the car there in perpetuity. That just means that there's another car taking a parking space. Furthermore, I would say that, I'm sorry, Ms. Crystal, I didn't get your last name.
Cordo. I'm sorry, counsel, just if you wouldn't mind, the magistrate began to speak. I was creating a picture just because I wanted to give some background leading up into where John is today.
Well, I wanted
But
to
just to fast forward to today and his testimony that they're willing to work with the city. It's March, and I personally spoke with the business manager and whoever the owner is out in California, and his contention at that point was, we want to work with the city. I have dated pictures continuously over the months that depict a picture contradictory to that statement, we want to work with the city. There is never a time. The trailers is one thing. The outdoor store, all of the items that are in the trailers, it's an outdoor flea market. They do not have, and my point in stating that they have outgrown the space is that, as John just mentioned, the argument he made is absolutely valid because there is never a time, even after business, everything is still as is. If it's a different trailer with a different tag on it, there's no way for us to know that. The items are still there. There are items outside, bicycles, you cannot park.
So it's not about. So the issue with the trailers is that day or night, there's a trailer in those particular spots.
And
on the
items
property.
on the exterior of the trailer that are blocking the roadways.
And I think, counsel, that's the rub here. Where is
Mis-
that yes, if you put one trailer in and take one trailer out, you break a chain. But here what they're really saying is that no matter when you come, no matter when you visit the property, there's a trailer there. And you can't have that.
Well, if I could, to your point, Your Honor, and to Ms. Cordro's point, I believe you mentioned that this was instituted by a council member that had a concern over being able to traffic through the property, and
Yeah, she's just telling you the nature of
Right.
the complaint.
right. But we've introduced to the record the fact that that is not an alley. That is our client's property. There is no access through the area between the trailer and the store. I don't mean to be argumentative, but I'll say that I've just gotten involved in this case, I know Mr. Cook very well, and I'm happy to reach out to him. You may have contacted the ownership, which is in California, when they said that they would be willing to work with you. I think what they want to say is that they're willing to make improvements to the operation as may be, allowed by your code, but we haven't heard what those are. And in fact, that was my question this morning to you, Mr. Dorville, is how could we make this situation work? Because this is a community, asset. It's obviously popular, and the record will show that although this enforcement action began a few months ago, this has been happening since 1983. So it's never been a problem for the city and for these owners. And obviously, they're providing something that's of benefit.
I don't
How
wanna
can we
cut you
not
off,
come
but
to
I
a
just-
mutually agreeable solution?
Yeah, I understand. I'd like to have the zoning manager, Mr. Cook, testify to why they're outside their zoning, which is really the crux of this conversation. Mr. Cook, if you could.
Mr. Cook, can you raise your right hand to be sworn in, please? Do you swear or affirm that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say I do.
I do. Mr. Magistrate. So the property is zoned C3, and within our code, it just doesn't allow outdoor storage at all.
Why not? Tell us the language in the code, because what has been proffered thus far by council is that retail businesses cannot store items outside of the building, that it must be self-contained within the building. However, there's an exception for secondhand goods that are being sold. Goods that are being sold secondhand are exempted from this particular requirement. So let's speak to that.
Mr. Cook, if I may,
I'm not aware of that caveat in the code that secondhand goods can be stored outside. It's just universal. You just cannot store items outside in that zone.
Now this is a thrift store, so we can all concede that a thrift store sells secondhand goods. But is the city saying that it may be a thrift store in its use, but as the code sees it, it is retail space, and thus all activity must be taken place inside? Council?
For clarification, when you're talking about activity, are you talking about them doing commerce, the sale and of their goods, or we're talking about storage?
We're talking about the purpose of the business, which is the sale of secondhand goods.
Okay.
They're saying that that purpose is within its zoning, and within that, they are allowed to have these things on the outside of their facility.
Judge, but the sale is separate from the storage of what they're actually, if they're zoned,
They say it's incident to. They're saying that it is incident to it. That is a natural byproduct of what they do. So the question is, are they retail as defined by the code and must be, all activity must be within inside the building, or are they not?
If I may, Your Honor, I would go to the code and see how we define consignment.
you have a definition for consignment, if I may, Your Honor, and you have a separate definition for thrift store. I have both here. I've introduced thrift and retail to council.
Okay, so I'm gonna go with consignment shop. It says means an establishment wherein goods limited to clothing, shoes, and or accessories for adults and or children are sold by the operator of the shop, acting as an agent for the owner of such goods in return for a percentage of profits or other considerations, such as goods may be comprised of a combination of used goods and new goods, or the use of goods only.
So, now you've introduced a third definition to the case. Now the code, what does the code speak to that you've been cited under? Mr. Dorville cited under a particular code. And what does that code speak to?
Your Honor, I believe it's a generic reference to violation of section, Article 4, ZPU zone prohibited use is the copy that I have
So
of the violation.
Just Article 4?
If I may, Your Honor, in that, dealing with Article 4. Article 4 speaks to, land development regulation, the uses that you are allowed to, permitted within the city.
Right.
So we have a table within the Article 4 that specifies certain uses that can happen in certain zones.
Correct.
So in that vein, in his zone, outside storage is not allowed. Therefore, code enforcement made a reference in their citation.
Is that
boom.
regardless of the occupational license they hold?
So as I was thinking about this coming over in this short amount, that came to my mind. So what if we have a certificate of use and the certificate of use identifies storage as a component? Then it does take on a different light. I would say.
But, Mr. Cook, if I may ask a question, Your Honor, I looked for storage as a use under your, matrix of permitted uses under C3, and it doesn't appear. So that's what took me to just the definitions of uses. My understanding is that this is a thrift store under your certificate of use. This is what my client tells me. I don't know if you have that record. That it is not maybe a consignment shop as well, but it's first and foremost a thrift store under the CU. And when you read the definition of thrift store in Article 4, it's different than the one in for retail, and it doesn't contain that provision that requires that all activity take place within an enclosed building. And that's the point that I was trying to make earlier. So there does seem to be a purposeful distinction that was made by, the powers that be when they drafted your Article 4, perhaps in recognition of the fact that this thrift store, is an important asset to the community. And again, what we want to do is try to make this work in a manner that's mutually agreeable to the city as well as to our client.
Guys, I know you guys keep saying you guys want to make it work. I just want to conclude the case. So, you're contending, they're saying, listen, you're in violation of Article 4?
Yes, sir.
That's it. That you're in violation of Article 4. Article 4 has certain uses for the land. And storage is not one of them in this area. They're saying, and they're considering that the trailers on the property are storing items inside them and are remaining continuously, meaning that a trailer is always on the property, but storing goods.
That is correct, but storage doesn't appear as a permitted use under any zoning district. So I think it's assumed, it's implicit that storage is a necessary component of any
business.
particular, exactly.
So if I may clarify, outside storage is allowed in certain zones. In the industrial area, it is allowed. So this is a commercial area. This is considered the core. Even when it comes to consignment strips, strip malls and things to that effect, we have certain criteria, specifically in thrift stores, that we don't even want a proliferation of that type of use even in that area. We have a separation distance that they need to meet to even be there. So if you're not even in, if you're within that, then we don't even allow it. So for me to speak to what Mr. Fernandez is talking about, when he's speaking of there was a certain type of implied need for this to be there, really the city says in this holistic impression of these type of uses that we really don't want a proliferation of them, specifically in this area, that we want a separation because we want certain uses in our downtown that brings about traffic and certain type of development that we would like to see. This one, You can see what we have going on here. You have a thrift store, a consignment store. It has outside storage, and that's not something that we really don't want as a prevalent element in our
So
downtown area.
we're not conceding that it's storage. You're calling it storage. It's a loading operation. Trucks move in on a daily basis, and the merchandise gets brought into the store. So it is a continuous loading operation, but it is a loading operation nonetheless, and it's not taking place in a public right of way. It isn't an outdoor storage. There aren't any outdoor sales taking place. It isn't a flea market. I don't think there's any evidence to that. I was there this morning.
At the end of the day, when the sun sets, are all the items inside of the facility?
Yes, they are. What happens is, Your Honor, that there is one room in the back of this building that is where all of the employees sort through the items that get brought in. During the day, they are working, actively doing that. It is a large space and a lot of employees. At night, once the employees leave, all of the items that remain in the container are brought into that space because now there's space for them. And in the morning, the same thing gets repeated.
Okay. I am interested to know what's their certificate of use.
So I can have my clerk see if we can pull that up.
Yes,
So-
let's pass it till we do that. All right?
Thank you, Your Honor.
Let's call the next case.
The next case is item 112, Rodney King and wife Stephanie. Edme St. Louis is the officer. The case number is CEE XP 2019-00029, item 112.
What number again? That's too much talking.
Counselor 112.
You should keep them with you until you come back.
Well. Who's here on behalf of this property?
I'm sorry?
Go ahead and make your appearance for the records.
Okay, I'm Rodney King. I'm the owner of this property.
Okay.
And,
Mr. King, you've been made aware of the violation, correct?
yes, I'm made aware of it. I was out of town when this arrived, but anyway, I'm aware of it now, and I've corrected the violations as they're itemized here. And I would like to have a little extension of time so the officer could come back and look at it again. And I would like to make the point that the building, I was the builder. I'm a retired contractor, and I built this building for myself. And the building is not painted. It has a product called Marblecrete on the outside, which is a product of colored plaster, so you never have to paint a building. It's a really nice product. And when I built it, it cost me over $2,000 extra to do this instead of just stuccoing the duplex. And it's really nice because it means you never paint it. There's no peeling paint. It's never an issue. But it does get dirty and fade a bit, and then you have to pressure clean it and renew it. So I have done all that, and I would like a time extension to have the officer come back and take a look, or I have photographs here of it now if you'd like.
If you
to
have
see those.
photographs of it now, then we
Sure.
can take care of it now.
Yeah, okay. There's the front. The side, which looked bad, is now looking good. Yeah, okay, yeah, so there's no problem now.
Does it go ahead and make your appearance for the record?
City of North Miami Code Compliance Officer, St. Louis. This property, which is 13950 Northeast 13th Avenue.
Is
To
it-
my own discretion, I feel like it could have been done a bit better because the abutting properties, I cited them for the same thing too, and both property owners went ahead and painted and even put different coating on the property as well.
You have photographs from when you cited?
Yes.
All right. You have photographs from where they stand now.
Yes.
All right. Please present photographs.
I have photographs from when I initially cited him.
And he has
Also-
photographs from now. So
Yes, and I also have the same photographs he has from the 27th when I made my final reinspection.
and it was done. Was it done at that time on the
I
27th?
can't remember, was that when it certainly looks different, right?
Yes, it looks way different
So
from when I
they're the same
initially
as your
cited them.
photos.
Yeah.
Okay.
yeah.
Present the photos.
Because basically, let me make a point. The other people I spoke to them, they're intimidated by the violation. They painted it. I don't want to paint it. I am in the process of trying to sell the building. It's a sales attribute to tell people, look, you never have to paint this building. It has. I spent the extra money to put this Marble Creek coating. I have the printout from the company that makes it, and it will never look quite as good as paint. But it doesn't peel, it doesn't flake, it doesn't, it's a different product.
But does it fade?
It's white, so it doesn't
okay.
really fade. It's a white building.
So as long as you pressure clean it, it's okay.
It's not as good looking as a nice brand new paint job, but a brand new paint job only looks good for the first year. Then it looks about the same as my building does. So,
Okay.
I mean, there's certainly nothing peeling, and there's nothing, no raw stucco exposed or anything like that.
Yeah, but there is serious fading.
Well, it's not quite white. It's a little gray in places.
It leaves the building spotchy. I
I'm
mean,
sorry.
some areas of the building are brighter than the other areas of the building. I mean, and that is the city's contention, is that the building in its appearance should have uniformity, and it doesn't, but based on these photos. So you're gonna have to do something more than what you've done thus far. Even in the finalized pictures that Ms. St. Louis has provided, I can see the discoloration. Yes.
Well, on the front.
Some areas are darker, some areas are lighter. That's discoloration.
I can redo the front between the two front windows. This part.
When you paint a building, it's white all around. If you paint it white, it's white all around. It's not dark in some areas and light in other areas. When it's done properly, it's uniform. So as long as you have a uniform looking building, then okay. But if not, you're not yet in compliance.
Where specifically does this not look uniform, other than between these two front windows?
Speak on the mic if you're going to be talking, or you can go back to the.
Okay, can I hand those back? Asking. 'Cause these are the early ones.
No, I made my own view of them.
Can you tell me where specifically it doesn't look uniform? There, yeah, I agree. Well, where on the rest of it, like on here, there's nothing, it doesn't look, the back is complied. In the front, where else does it not look uniform? That's his things hanging down. No, I'm not referring to the. What are you referring to?
All right. So I find out a violation does exist, it's cited. I'll give you 30 days. You don't need more
All
than
right.
30 days.
30 days and,
All right.
okay.
I give you 30 days, making it, must
Make
abate
it,
by
make
May
it look
8th.
uniform is the goal here. If I can pressure clean it to make it look uniform, that will work, right?
Yep.
Yep,
May
Okay.
8th. If not abated by May 8th, then it's $250 per day until abated.
Okay.
All right?
All right, thank you.
The next case is item 122, Teresa Diaz. Edme St. Louis is the officer. The case number is CEEXP 2019-00023, item 122.
Morning, Your Honor. Cindy Diaz on behalf of Teresa Diaz, 1330 Northeast 137th Street, North Miami, Florida, 33161. This is with regard to a violation as to rusted paint of a patio enclosure. Your Honor, we don't dispute the violation.
How much time do you need
I'd ask for 60 days.
to paint?
Yes, sir.
Why so long?
It's my mother's property. She's elderly. I'm assisting her as her daughter, so it's just a matter of me coordinating the logistics and seeing that it gets done. I think 30 days should be enough, but in an abundance of caution, I'm just asking for 60.
All right, so you realize on a paint job, if I give you 60 days and you come back and tell me it's not done,
That's not gonna happen.
I'm gonna go like,
And you'll be in your right, but that's not going to happen.
all right. All right. Find out a violation does exist as cited. Issue an abatement date of June 12th. Not abated by June 12th, then it's $250 per day until abated, and there shall be no continuances.
Thank you,
Magistrate,
sir.
if I may, City of North Miami Code Compliance Officer St. Louis, per the violation I mailed out, it states not just the patio cage, but also the walls too, like to the right of the property. It needs painting.
Okay.
Whatever the violation comprises, we'll take care of.
No problem.
Thank you, sir.
The next item is item number 13100 Sunrise Plaza LLC. Gary Beswick is the officer. The case number is MHVIO 2019-00044. Item number 1.
Sunrise Plaza. Who's here?
Good morning, Your Honor.
Good morning. Go ahead and make your appearance for the record.
My name is Moises Bija, and I own the property in 13100 to 13180 Northwest 7th Avenue. And I come in here to show you my architect, he make the plans, and then he applied Friday, and we need it by 3 months, please. And
Okay, so you don't object to the violation, you just want additional time.
well, the violation was a petition only. They're making 3 holes and the tenants, when he do that, I sign him some papers for the permit. I don't know what happened. And all of the song is coming with the no permit, and now we got it, the architect, Isaac Bihar, and he's a general contractor, and he's gonna do everything.
Okay. Any objection to the 90 days?
Yes,
Please.
All right.
because this,
Yeah, he talked to the officer very well.
Gary Bezick for the City of North Miami Building Department. Technically, this is something that's actually going back to 2017. October 26, 2017. Basically, a violation was open and closed, and the owner was supposed to take care of the problem before he rented again. But he didn't do that. He went in there and altered it and rented. So, adjudication in 30 days.
All right. All right, find out a violation does exist as cited. Issue an abatement date of June 12th. Not abated by June 12th, then it's $250 per day until abated.
There is one more case on that property, item number 2. Gary Beswick is also the officer, and the case number is MHVIO 2019-00045.
And it is the same, it's
Same
the
thing.
same nature. Yeah.
Yes, same thing.
Yeah, so
Okay.
same outcome. That's why I gave additional time. I
Okay.
figured that's what was happening. All right, thank you.
Thank you. We are very close with the city, for many years.
All right.
I donate. to
Everybody
the
seems to be very close with the city these days.
so many years ago, you know. And the one I make it the red one with the city, the face, and the only one I do is me.
Okay.
The building was beautiful in there, and I donate to a police department for, you know, the Steve Bauer, the police died in the Peace Lab Bank, and I donate for 12.
Go ahead and call the next case.
I do a lot of things good to the city.
The next case
I've been together
is
with
item
the
number
city.
3.
Thank you.
John Dorville is the officer. The case number is CEIVY 2018-00460. The customer is 14245 Northeast 8th LLC.
Thank you, Your
Item
Honor.
number 3.
Your Honor, my son is a lawyer, showing him, please. I want you to see who is the lawyer.
Okay. Oh, another Benjamin, huh?
What, item number 3?
All right.
Oh,
Your
John.
name,
Yeah,
my son,
yeah.
he's in California.
The next case is item
He's supposed to be
15,
here, but he
Arsenio
got the flu.
Telsey. Jose Perez is the officer.
All right. Thank you.
Case number
Appreciate you.
CEOSV 2019
I don't.
00007.
Give him back his son's card.
Arsenio Telsey.
He told me,
This podium.
he cannot come today, but
Paila. Pila.
thank you very much.
Take care.
Have a good day,
Bye.
This is item number 15.
Thank you. Go ahead and make your appearance for the record.
Good morning.
Good morning.
My name is Ansenio Telsi. I'm living on 2610 Northeast 2nd Avenue.
All right. You've been made aware of the violation, correct?
Yes. That's it.
Are there any objections to the violation?
Okay.
Are there any objections to the violation?
My truck been parked there.
Guys, I need you to. I'll give you time to say whatever you want to say, so long as you answer my questions first. All right.
Okay.
Is there any objection to the violation?
Yes.
All right, Mr. Which one is this? Mr.
Perez.
Perez. Yes. Go ahead. Whenever you're ready.
I'm sorry, which was the?
Number 15 and Arsenio Telsey, 12610 Northeast 2 Avenue.
Got it. So with this case, we had a history of the vehicle being stored there. At the time of the inspection, the oversized vehicle was being stored on the side of the property where the resident was working from inside the vehicle. It appears that he runs some sort of business with washing machines, I guess, that he repairs. In case he did remove the vehicle, but we want to get an adjudication so that if he were to bring back the vehicle, we could take it as a repeat offender.
Oh, okay. All right. Mr. Telsey?
Yes. My truck been parked there when I'm loading something or unloading. I have the place to park my truck in my church. The truck might be there for all day, something like that.
So
Be
you
there
don't,
for 1 hour, something like that. When I move, bring something or unloading.
so you're saying that you only use the vehicle to unload?
Yeah, when I bring something, not all the time. Maybe before 3 months, sometime when I bring something to my house or we remove something.
But you store the truck at your church?
Yes.
At the date of the inspection, I passed by in the morning. The vehicle was there. As I passed by in the afternoon, it was still there. So it exceeded the 1 hour grace period that we have for the unloading and loading.
There you go.
When I made contact with the resident, he was working from inside the truck, I guess fixing maybe a washer or something. But I did explain to him that he did have a history of this violation occurring prior to it. And I had explained to him that unfortunately he can no longer park it there. As of right now, he has not parked it there. But again, we would like to get the adjudication due to the history with the case.
Okay. I find that a violation did exist as cited, and thus you cannot park the vehicle at your residential property for more than an hour. Okay?
Okay.
All right. Thank you.
Thank you.
Thank you.
There is no fines because I take judicial notice that there's currently no violation taking place. All right.
Thank you, Your Honor.
John? Item 35 for John Dorville.
All right. Recalling the case of D&D Company Properties LLC. So what does our use say? What does the certificate of use say?
It says both, retail / thrift store.
So, Your Honor, if I may, please. So when I look at the definition of thrift store, it doesn't speak to what was somewhat spoke of, alluded to, that in the context of a thrift store, you can have storage and things to that effect.
So tell me the definition.
So the definition says, a thrift store or resale shop means an establishment wherein secondhand articles are sold, such as clothing, shoes, accessories, furniture, and other assorted items, the value of which is only a fraction of the original cost, for which price guides are not available and which normally have no collectible or antique value. This term shall not apply to businesses which sell primarily new goods and which may occasionally sell secondhand articles as a result of trade-ins or unclaimed merchandise.
So no business then can be designated both retail and thrift.
That's absolutely correct. Right on the money, because retail specifically says it only applies to primarily new goods. That's exactly right.
But what is this distinction between what's being stored on the property? How does that change? Whether it's retail or whether it's thrift, how does that change what's going on the property in terms of the bins of clothing outside, the trailers constantly on the property? How does that change it, whether it's retail or thrift? How does that change that scenario?
I don't think I don't know, is that directed to me, Your Honor, or to?
So for me, Your Honor, it doesn't change anything.
Okay.
For me, if I read the definition and it said in it, as you spoke earlier, as an incidental use, storage as component in the definition, then I would say, then I would make a concession that within the framework of this activity, that we speak of storage being one of their components.
Okay.
And then I say, all right, then we have something to hang our hat on. But this is not the case in the definition.
Now, it's clear, and I think council can agree that it's clear that retail, the city intended for retail operations to be contained within the facilities on the property. All of its operations, whether it was storage or otherwise, all operations of that business must be contained within the building.
Yes, sir.
Okay. Now, what is council's argument with regards to why thrift store operations would not be required to do the same?
Well, because I think that the loading and unloading of goods and products would necessarily need to take place within the enclosed building, arguably. Some codes require that in different municipalities. City of Miami, as you know, Mr. Cook, requires that loading take place fully within an enclosed building. My point is simply that the loading aspect of this use is not prohibited by the definition of a thrift store under Article 4. And so our position is that what we're doing is loading and unloading. I understand the city's position is that we're going beyond that and that we're actually storing because of the time that the time that it's taking to get the goods into the building. I think this is really, the crux of this is all about the time that it's taking to move the goods in and out of the building.
And the fact that the business constantly stores trailers on the property, which it's not allowed to do.
So again, we're moving trailers through on a daily basis. We're not storing them.
I'm gonna say that this magistrate finds that if a trailer is on the property in the morning and a trailer is on the property in the evening, then trailers are being stored on the property.
Even though it's a different trailer?
Even though it's a different trailer.
We would,
Because a trailer never leaves the property, such that the space for which it never leaves the property, such that there are always trailers on the property. And they're saying that you cannot always have trailers. So if you want to take out the word storage, you cannot always have trailers on a property. Maybe that's a better way of looking at this. You cannot always have trailers on this property. That is prohibited for this particular area. Okay, so with that being taken away, it's this case, I think that solves this case, doesn't it? That's this case.
City's looking for an adjudication, Your Honor.
All right. And as such, find that a violation does exist as cited. Issue an abatement date of how long would you like, counsel?
well,
And understand this, counsel, by this adjudication, what I am prohibiting by this adjudication is the constant, instead of using continuous, I'm gonna use the word constant, the constant appearance of trailers on the property. Okay?
understood. I did have a conversation with Ms. Crystal Cordeaux, and I don't want to speak for her, but I believe that she is agreeable to giving us some time to come up with perhaps an enclosure so that this area that is on our client's property, as we've shown through the record, not a right-of-way, where we can enclose some of these goods so that it isn't, in their view, storage.
Okay. How much time is the property owner looking for?
Well, I would look to Mr. Cook we can probably put together an application and a plan fairly quickly. I don't know what sort of process it would require with the city in terms of getting an actual permit, what you would require.
Is a permit required, or is this a change of use? Because, I mean, it's one thing if you're just getting a permit. A permit is what the permit process is. But if you're getting something like a variance because you're kind of switching up the use, then that's different.
So in that context, if they were building a new structure so they could house their goods that are servicing their primary, then
It's
I
a
would see
permit.
that as
A permit.
incidental use to the actual primary source, but they would need to go through a permitting process, and with the new building, probably would need to go to the Development Review Committee for that. You need landscaping and things to that effect, so
Sound
it
like-
would take a minute.
Sound like 120 days to
Yes.
start out with.
Mhm.
All right. So, what are we looking at? July? All right. So, it needs to be abated by July 10th. Not abated by July 10th, then it's $250 per day until abated.
Wow.
Thank you.
Thank you, Your Honor.
The next item on the agenda is item 18, Boris Sotolongo. Karen Jean Lewis is the officer. The case number is CEBPR 2019-00002, item number 18.